where I'm comfortable, where I can kick up my feet and do what I want to do. I can invite my friends over, or I can tell my enemies, hey, you can't come here. I have control over this. The warm, fuzzy feelings that we have about the property we own comes from the rights that we have as property owners. We've been talking about land, improvements, and rights, and that's the definition of real property. The rights are probably what, to most of us, are more important because that's the benefits. Think of rights as the benefits we get from property ownership. In real estate, when we're talking about the rights or the extent of control or interest that we have in real property, we refer to that as an estate. An estate is not a large home on sprawling land. In fact, an estate has nothing to do with the size or the type of the property. Any type of property can be owned, and we have our ownership interest then is an estate. It could be something as small as a cemetery lot or a tiny home, our homes. It could be a farm, an agricultural property. It could be a small business, a factory. Any type of real estate that we own, we have an ownership interest, and our ownership interest is referred to as our estate. The estate then is the degree, nature, or the extent of an individual's ownership interest in the real property. We have basically two types of estates. The first type of estate is a freehold estate. This is an estate of ownership. And we have three types of ownership estates. A fee simple absolute, qualified fee estate, which is sometimes called a fee simple defeasible, and we also have a life estate. We have the other type of estates that we can have are non-freehold. If it's non-freehold, you don't own it, so it's a leasehold estate. These are estates of possession. And we have four types of these. The first one is an estate for years, a periodic tenancy or periodic estate, an estate at will, and an estate at sufferance. So we've said then that the freehold estates are estates of ownership. This is with an indefinite duration. There is not something written in the deed that says our ownership interest is going to end on a certain date. We're going to own this indefinitely. It is the ownership that has the complete bundle of rights. Fee simple absolute is the first type, and it has the complete bundle of rights. Think of it as absolutely the best or simply the best. Most complete, the highest degree of ownership interest an individual can have in real property. The greatest degree that we can have in real property, like I said, was the fee simple. And it's going to last for a long time. It could be a lifetime or even longer. You might ask, well, how can I have ownership beyond my life? Well, that's referred to the fact that when you own a property in fee simple, it is inheritable. You can will it to someone. Or if you don't have a will, it'll pass according to the laws of descent, which we talked about a week or so ago. That if you don't have a will, then North Carolina has intestate laws, and will pass according to the intestate laws. It's fully transferable. Another word for being transferable is alienation. We talked about that when I separate myself from something, I become alienated, I transfer ownership, then I no longer own it, I'm separated from the property. So it's fully transferable. And a fee simple absolute estate is inheritable. I can will it. If I don't will it to somebody, it will pass according to intestate succession laws. So I have control over it for my lifetime and even beyond. The next type of freehold estate that we mentioned was a fee simple defeasible estate. This is conditional ownership. I own the property on the condition that something happens or doesn't happen. So the owner retains ownership by doing or possibly not doing some action specified in the deed. If I were on the wrong team and we lost, I would say we had been defeated. So if I lose my ownership interest, my ownership has been defeated. Maybe that'll help you remember the word defeasible, defeated. The estate can be defeated. This is also known as a qualified fee estate. So in a test question, you might fee simple Defeasible, you might see fee simple, subject condition, subsequent, but either type of these defeatable estates are qualified fee estates. You have to qualify to retain ownership. The first one is a fee simple determinable. This one is the one that you retain ownership as long as you continue doing something. If that action is not continued, then ownership would be lost. If ownership is lost in a fee simple determinable estate, it's automatic. In other words, there's no court action needed. You don't have to go to court and get a court order. It's an automatic reversion to the original grantor. If the original grantor has passed away, it would be to the original grantor's heirs, but it's an automatic reversion. The next type of qualified fee estate, or defeasible fee estate, is one that's subject to a condition subsequent. This is the one where you don't do some action. That's written in the deed on the condition that some specified action does not occur. In this one, if that action does occur, in other words, the deed condition is violated, it does take a court action. The grantor or their heirs, the folks that are wanting to regain the ownership, would go to court. The judge would listen to the testimony of both parties, make a decision, and the court would decide who is the rightful owner. Last week, we talked about some other situations when there was a dispute on title, and we talked about a lawsuit that would settle that. What did we call that type of lawsuit? Remember?
What claim?
A quiet title suit. Yeah, a quiet title suit. In other words, there's some dispute, there's a cloud on title, you go to court, court makes a decision, he decides who's the owner, that lifts the cloud, which clears the title. So this is another example of a quiet title suit. The difference between these two qualified fee estates comes from the wording in the deed. So long as you do something or don't do something. If you run across one of these in your practice, because quite typically, especially if we're listing a piece of property, we're going to pull the deed and look at it. You need to get legal advice. We're not lawyers. We shouldn't be trying to interpret the difference between a fee simple determinable and a fee simple subject to a condition subsequent. But we need to raise the flag. Remember I said we're real estate agents are sometimes flag wavers. We aren't experts in any field. But we either raise the red flag and say, hey, stop, don't go any further, or we raise the yellow flag and say, proceed with caution. This is a proceed with caution situation. You need to get legal advice because because they are both fully transferable and inheritable, we have to be concerned about how the deed condition affects the future owner. When something transfers with property, runs with the land, what was the word that we used to describe something that runs with the land?
Appurtenance.
Appurtenant, that's right, thank you. It's appurtenant. So if it's appurtenant then, it's going to transfer to the other owners. If it's sold, given away, or inherited, either way, that condition is going to be binding on future owners. Do you think that might be something that a buyer would need to know?
Yes.
Absolutely, they would need to know, so that would be a material fact. But we would need legal advice as far as deciding what to tell the future owners about this situation. What do you think about this? Sam gives property to a local college with a deed condition stipulating that the property can never be used for anything other than scientific research. 23 years later, the property sold, and the college relocates maybe to an urban area. And the company that bought this downtown location decides they want to tear it down and build a mixed-use residential business center. Do you think that this would be a violation of the deed restriction?
Yeah.
Yes.
Yes, it would, because a business center is not scientific research. Do you think the fact that it's not the college that still owns it, now that there's a new owner, does the new owner change this in any way?
No.
No, it does not. What type of defeasible or qualified estate do you think this is?
Fee simple subject.
Determinable.
How many thinks determinable? How many thinks subject to a condition subsequent? Well, Charity's right. That's the one it is, because look at the phrase that we said, never can be. Never can be means don't do, right? So this is the one where you can't do something. So it would be a fee simple determinable. Fee simple subject to a condition subsequent. Next type of freehold estate we're going to discuss is a conventional life estate. Now this is deeded ownership that ends with death. It's still an indefinite duration because none of us know when we're going to pass away. If we did, we'd plan around it, right? But we don't know. But it's going to end, if we're a life tenant holding a life estate, it's going to end when we pass. I cut and pasted a couple of life estate deeds from Google. You can find anything on Google. Just so that you would see that it is a true deeded ownership. The life tenant's named in the deed, and it's called a life estate deed. The life tenant then is the the grantee, the owner, because they're receiving. Remember we said E's receive, Or's give. So the grantee is receiving a life estate. They're referred to as the life tenant. This can occur a couple of different ways. First, it could be a fee simple owner decides that they want to give a life estate to somebody, and then they would create a life estate deed signing. They're the grantor, granting a life estate to somebody. Example of this might be maybe a father wants to make sure that a daughter has a place to live for the rest of her life. And so he creates this life estate. If the father dies before the daughter, what is going to happen to the property? She's staying in the family home. What's going to happen to the family home? She gets to continue living there, right?
Right.
Her brothers and sisters or the other heirs can't come in and say, hey, you've got to get out of this place because we're going to sell it, get our part of the inheritance. They have to honor the life estate and allow her to live there. Now, after she passes away, then they would be free to sell it, or whoever inherited at her passing would be free to sell it and do something, dispose of it. Another way that this might occur is an owner who owns the property decides that they want to go ahead and give this property to someone else, but they want to reserve for themselves a life estate. Sometimes this occurs when maybe someone is aging, or the estate plan is beyond the scope of this class. We're not going to talk about that. But there are some reasons why, as a person gets older, they may want to go ahead and transfer assets out of their name. You have to talk to an attorney about that. But if that were the case, one vehicle that they use is the owner goes ahead and deeds the property maybe to children or a charity or whoever they want to receive it at their death, and they reserve for themselves a life estate. In either case, the life tenant is the grantee because they're receiving the life estate. They're receiving the life estate deed. Upon death of the life tenant, the life estate is going to revert back to the original grantor. If the original grantor has passed away, then it would go to their heirs. This is called a reversionary interest. Think revert, so to help you remember, reversionary interest. The grantor has a reversionary interest. Do you think there might ever be a case where somebody might say, well, I really don't want the property back. I want to give someone a life estate, but I'd like at their death for that property to go to somebody else? Yes, there could be some situations like that. Maybe the situation with the father, he gives a property to the life estate to one daughter, but at her death he wants the property to go to his children. He maybe not come back to him, even if he were still living, he would want to go to his children. When that's the case, when the original grantor decides he wants to go, the estate to go to someone other than himself, reverting back to himself, that's called a remainder man. This is a third party. The first party being the grantor, the second party being the grantee, the life tenant. This would be a third party, the remainder man. The remainder man has a remainder interest in this property. So whether it's reversionary or remainder, reversionary for the original grantor, remainder interest is what it's called with a remainder man. These are called future interest. In other words, I'm going to get some rights in the future. The remainder man or the original grantor has a future interest in the property. They will get those rights when the life tenant passes. Let me give you an example that might help explain this. Sometimes I think real life examples paint mental pictures in my mind. I have in my family had a situation that occurred in the late 80s, and I think it was 87, where my brother-in-law's sister was on a train to visit her mom. It was an Amtrak train and it derailed. It was a horrible accident, and it was the engineer's fault. In fact, he spent prison time, I think about 10 years in prison over this. But the folks were called in rubble for a long time. In fact, my brother-in-law's sister was in the rubble long enough that they actually were able to leave Charlotte, fly, and get up to where she was before she was able to get her out of the rubble. So they were there when she was rescued, and they rushed her to the hospital, and she lived about 3 hours. One of the last things that she said to her husband was, "Promise me you'll always take care of my mother." And he made the promise that he would. So obviously in a situation like that, there's some liability, and there was lawsuits and a judgment, and he received an amount of money. He felt like that money came from his wife's death and should be there to protect his children for the future. They get educated and, protect their life in the future. So he went to a financial planner to get advice, and he said, now the first thing I'm going to do is I promised my wife on her deathbed that I would take care of her mother. So I'm going to buy a condo here in Charlotte, and I'm going to move her mother here so we can take care of her. He said, but other than that, I'm wanting my children's futures to be protected. And the estate planner said, well, what you need to do is not give your mother a condo. Because think about this, if you give your mother-in-law the condo, when she passes, who's going to get ownership of that condominium?
Her heirs.
Her heirs, right, which it was only 2 children. The daughter and my brother-in-law would have been my daughter-in-law, my brother-in-law. So anyway, he said what you need to do is to set up a life estate. Then she can have it for the rest of her life, but at her death, you can name your children as a remainder men, and it will go to the children. So that accomplished that for everybody, and everybody was happy with that situation. So during the life of the life tenant, that's what the life tenant owns, is a life estate. The original grantor has a reversionary interest, which is a future interest. The remainder man has a remainder interest, which is a future interest. Upon the death of the life tenant, the estate is going to revert to the original grantor or go to a third-party remainder man in fee simple. Now, the life estate is gone, so the grantor or the remainder man, again, have a fee simple absolute estate. During the lifetime of the life tenant, they have some rights. In fact, I cut and pasted this sentence right from one of the deeds in the earlier slides. The deed gives the power. The life estate deed gives full power and authority in the life tenant to sell, convey, mortgage, lease, or otherwise manage the property. Let's think about that. They can sell it. But what are they selling?
Interest.
You can only sell what you own. They're selling the life estate. Right, they're selling the life estate. Whoever purchased it is purchasing a life estate. When is their right to possess that property going to be over? When the life tenant dies, not when the new owner dies, but when the original life tenant, the person named in the deed, they can convey, which sale is a type of conveyance, but conveyance means more than just sale. It could be given away. In other words, dedicated to the government or something like that. They could mortgage, if you could find, don't think you could find a bank that would loan money on it, but hold on to the thought about mortgage. We're going to come back to mortgage in a second. It could be leased, and the life tenant could receive the rent. And then the last phrase there is otherwise managed. I call that the catch-all phrase, because this is talking about the life tenant has the right to live on the property, manage it, keep it up, maybe farm it, get proceeds from the farm. If they rented it, they would be able to keep the rent. And in fact, the legal term for this is estovers. It's a right to use the property resources. The life tenant has the right to use the property resources during their lifetime. They can farm it, they can lease it. It's 2 good examples of that. I said we were going to get back to mortgage. I've run across these life estates very few times. I say they're very rare, but I did run across another situation with my family where my brother had called me once and asked me about a timeshare. I actually had been, a couple years prior to that, at the Rutherford County Courthouse researching deeds, and I like history, and I just got into some of the deed books. And I ran across a life estate deed. I had never before then actually seen a life estate deed. So I looked at it, and what was curious to me is there were several pages of these life estate deeds. And I realized they were for the timeshares at Fairfield Mountain up at Lake Lure. And I realized what had happened then when those timeshares were first sold. And of course, this is many years ago. When they were first sold, they were sold then as life estates. And so the people bought them, they paid for them, they could use it the rest of their life, but at the end of their life, it reverted back to the developer. And then the developer could resell them. So that's what my brother was calling asking about. He said he was thinking about buying a timeshare at Lake Lure. Well, we live in that county, so I was a little puzzled, but he said he was going to trade it, go to Hawaii or someplace like that with it. But anyway, he said, do you know much about them? And I said, I do. He said, well, Madeline has one at Fairfield Mountain that she bought years ago. Now, Madeline's a friend of the family who's in her late 80s at this time. And he said, she wants to sell it. Her husband's passed away. She's not using it. Do you think this would be a good buy? And I said, well, I can't give you an opinion about timeshares or how that one works, but I can tell you this, those at Fairfield Mountain are life estates, which means when Madeline passes away, it's gone. It reverts back to the original grantor. So in that situation, he's really taking a gamble because this lady's already in her late 80s, right? So he decided not to buy it. But he went on to say that if he had bought it, Madeline had agreed to finance it for him. She was going to let him make a down payment and make monthly payments. In fact, she mentioned that when she originally bought it, that's what the developer did. She and her husband made a little down payment and monthly payments. Now that would be an example of mortgaging a life estate. And that's about the best example of a real life experience that I know. But help you remember that a life estate certainly can be mortgaged, and that would be an example where one was. Duties of the life tenant. There are certain things that a life tenant has to do. Usually they pay property tax. You pay tax on what you own. You own this real, you have an interest in real property, so you pay property tax. Keep the homeowner's insurance in force. Pay mortgage interest payments if there are any. And maintain the property. In other words, a life tenant can't waste the property. They can't do any, think of waste as devalue. They can't do anything to devalue the property. Let it go, not repair it, in some way devalue the property. In other words, what they can't do is encroach on the future interest. They've got to protect the grantor or the remainder man's future interest in the property. So let's think about how this might work. I told you that Mama could have the condo here in Charlotte and she could lease it. And then she could receive the rent. And in fact, that's what she did. She was a relatively young woman. In fact, older I get, the younger she was. But she later retired after moving here and decided she wanted to live at the beach. So she rented her condo here and went down to the beach and used the rent to help her afford the place at the beach. And that's okay, that's Estovers. Let's say a storm comes through and damages the property, and there's something on the property, maybe like timber or something that can be sold and used to fix the property. That's okay. What would not be okay is something like taking a piece of property where most of the value is in the timber and just clear cutting the property, and then that would devalue the property just so because you want the money. That would not be allowed. Something that wastes the property is not allowed. So, may a life tenant will his life estate? What do you think? No, it ends at death. There's nothing to will. It cannot. Is the life estate transferable?
Yes.
Yes, it's fully transferable. So then if you saw this in a test question, would a life estate be inheritable? No, it's not inheritable because you can't put it in a will, nor is it going to pass. There's nothing there to inherit. It's gone at the death of the life tenant. Now, what we've been talking about so far is your conventional, the standard life estate. There is a different type of life estate. This is called a life estate per ultra vie. Per ultra vie is an old French term that means for the life of another. And a life estate per ultra vie, one person is the life tenant, but another person's life is being measured. In other words, a life estate is going to end at the death of the measuring life, not at the death of the life tenant. Situation that I ran across is when I lived in Nashville, Tennessee. I had some friends, and they were married, had a couple of children, and the son, the youngest, had Down syndrome. And unfortunately, at some point in time, they decided to divorce. And as most divorcing parents would be, they were very concerned about their children, especially the handicapped child. And they wanted to make sure that he was always going to be taken care of. So what they decided to do is the father, as the grantor, gave a life estate to the mom, who would then be the life tenant, and said, Mom can live here as long as Johnny lives. At Johnny's death, then the life estate is over and we revert to the dad. In that situation, the measuring life is going to be Johnny, right? Mom dies, the life estate's not over because it's going to end when Johnny dies. When Johnny dies, if Mom's still alive, she's going to have to find another place to go, and it will go back to Dad. What if Mom dies before Johnny? There's still a life estate there. It hasn't ended. It's going to end at Johnny's death. So in this situation, would a life estate be inheritable?
Yes.
It would be. And in fact, probably Mom is going to name somebody in her will to take over that life estate who will take care of Johnny. And if she named that person in a will, say her daughter, for example, was named in a will, when you receive real property through a will, what is that called? Remember? We talked about it. Excuse me? Well, testate, you have died, testate, yes, so it's been willed. But the person receiving the property is called what? I didn't hear it yet. Devisee. Thank you, Christopher. Devisee. And it's a devise when you pass it by will, and you live as a devisee. As opposed to an heir is someone who inherits it by descent, where you don't have a will. But yes, the person that could be inherited. So this would be an example of an exception maybe to the life estate rule where it can be inherited. So upon the life estate for ultra vie, the way it works is upon death of the person whose life is being measured, it reverts to the grantor. Or do you think this one could go to a remainder man? It certainly could. A remainder man could be named as well. This one is transferable and inheritable. If I were writing a test for you, and I'm trying to test your knowledge on knowing how these things work, I think that might be a question I would consider putting in there, knowing what estates are inheritable and what estates aren't. So think back what we've talked today. Is a fee simple absolute inheritable?
Yes.
What about the qualified fee estate?
Yes.
Yes. What about a conventional life estate?
No.
No. What about a life estate for ultra vie?
Yes.
So remember that. Let's review them. A conventional life estate, you have a grantor who is signing a life estate deed, giving a life estate to a grantee who is a life tenant. This person's life is being measured and is going to end when this person's time runs out. So when their time runs out, their clock quits ticking, it's going to revert then to the original grantor, or it will go to a third-party remainder man, which has a remainder interest, and it will be a fee simple absolute estate. In the life estate for ultra vie, we have a grantor who gives a life estate to a grantee, who's the life tenant. But there's a third party whose the life is being measured against. This is the one whose clock's ticking. when their clock stops ticking, they pass away, the life estate will revert to the grantor, or it could go to a third-party remainder man and fee simple. Any questions about any of the freehold estates that we've talked about so far? No questions? Okay, you have a handout, and I'd like for you to go to the first 7 questions on the handout, choose a partner, just someone sitting close to you, and discuss these among yourself, answer the questions, then we're going to come back and talk about it as a group.
Can we get 2 of those?
Sure.
And you're moving on to the door. That's like
That's correct. It's true.
Yeah. We gotta meet some conditions. We gotta walk down.
The only reason why I chose this is because it's
They can never be subsurface.
Right. As long as
It's being subdetermined.
Everything after the sun.
You must do something. Yeah, but he does not, they do not do something, that's
How are you doing, man? Take some get it there, it was already researched, it was a bit of research. And then they do business, but I think they're going to change That's why I was that one, because I never know it's already been established as research. It was research, but it's
I thought back on the last, like very much said so over. So I got home. Sheila, do you have any more midterms? I think I might have left.
Sure, when we break, see me and I'll be glad to get you a copy of the When you go from discussing to gossiping, I can tell because the volume goes up. Sounds like everybody's about finished. Let's go over these questions together then. A freehold estate is an ownership estate. True. The degree of legal interest one has in real property is best described as one's estate. Remember, that's the definition of an estate, the degree of legal interest that somebody has in the property. A life tenant holds a fee simple, absolute estate. False. They hold a life estate. Sarah said we have the deed says life estate right on it. What they own is a life estate. Which type of ownership of real property would not be inheritable? A life estate, a conventional life estate would not be inheritable. An estate that can be terminated if a condition is violated is known as a defeasible or qualified fee estate. True. That is true. There's a condition that could cause a person to lose their ownership interest. What is a grantee's interest called when real estate is conveyed for as long as a specified condition is met, but will automatically terminate when the condition is violated? It's a fee simple determinable. As long as is your key there. As long as the current use is continued. And that's what you're looking for then, is what does it actually say in the deed? As long as the current use, as opposed to saying something can't be done.
So what's the other one?
Fee simple subject to a condition subsequent. Let me give you a couple examples. I've seen these actually in real life. A church someone gives the church a property and they say the church can retain ownership as long as it's used for a church or for religious purposes. That's as long as, a fee simple determinable. The other one might be that someone gives ownership to the church and they say this can be used as church property on the condition that no alcohol is served. I saw that. I was a member of a church once where that wasn't the case. Someone had given property to build a family life center. The youth went down there and had their sleepovers and potluck dinners and wedding receptions and different things. However, if somebody had a wedding at the church and they wanted to have a champagne toast or serve alcohol at the reception, they couldn't have the reception there. They had to go somewhere else. Because if they had served alcohol, because it says do not serve alcohol, then it would violate it, and that would be an example of a fee simple condition subsequent.
So
Thank
definitely
you.
grape juice on
Yeah,
community.
thank you, Iris, that helped
Great
me
use of community.
clear that up. Ms. Corey, did you have a question?
I said definitely grape juice for community, on community.
Corey says definitely grape juice for community. I guess that's true, no wine for community. Okay, let's go on. The deed reads that ownership is held on the condition that a specific use does not occur. This is an example of,
Be simple, subject to.
yeah, the fee simple, subject to a condition subsequent. That would be the example of not serving alcohol as opposed to continuing to use it as a church.
Yeah.
Any questions before we move then to our non-freehold estates? A non-freehold estate means you don't own it, non-freehold, so you're leasing it. A leasehold estate, you have a lessor who's the property owner, the landlord, and they're leasing your asset to a lessee who is the tenant in exchange for the rent payments. They have transferred the right of possession. Remember that bundle of rights? The lease, that's the legal document that transfers the right of possession to the tenant. The tenant then has the right to possess and use the land of somebody else, of the landlord. The tenant holds a leasehold estate. That's what it's referred to as, a leasehold estate, and it is a legal interest in that property. It's not going to be of infinite duration, is it? No, there's going to be a date in the lease, there's going to be a time period. In other words, at some point in time, this estate is going to end. So there is a definite, lease is a estate with a definite duration. The landlord then holds a leased, fee simple estate with a reversionary interest. Because when the lease is over, what's the right of possession going to do? It's going to revert back to the landlord, okay? So they have a reversionary interest. When the property is sold, the purchaser of the leased property buys it subject to the lease. In other words, they know the lease is there and they can't terminate the lease. They have to honor the lease. If they don't intend to renew the lease, or they want the tenant to leave, then they have to give them notice as provided in the lease document itself. You would read and see what notice is required and how it works. Or if there was no mention of it in the lease, then it would be, the default would be the state laws in the state where the property is located. But they're basically going to honor the lease, and then if they don't choose to renew or continue, they have to terminate according to the provisions in the lease or according to state law. Remember the statute of frauds we talked about a couple weeks ago? And I said this is the common law that says that any transfer of real property has to be in writing in order to be enforceable, which means enforced in court. I also told you that most of the time when I teach you something, there's going to be an exception. Well, the lease is an exception to that. A lease of 3 years or less does not have to be in writing in order to be enforced. In other words, you could go to court and the judge would listen to he said, she said, and make a ruling and decide about the lease. Once it's over 3 years, then the statute of frauds says, yes, it does have to be written in order for the court to hear a dispute about it. And of course, leases of that nature are probably commercial leases, long-term leases. We have 4 types of leasehold estates. The first one is a tenancy for years. Now, when I hear that, I think about a long time, a tenancy for years. Actually, this might be an example of the shortest term lease. The key to this has nothing to do with the length of time. It has to do with there is a definite end, a specified termination date. Maybe I want to go down to the beach for the weekend, and I rent a condo down at the beach. I show up on Friday. On Sunday, I don't wait around for the landlord to call and give me notice to leave. My time's up on Sunday, I'm leaving. The landlord is not waiting for me to call and give notice that I'm leaving. There's no provision then for it to automatically renew. It's over when it's over. It's finished. It's a drop dead date that it's finished. The next type of estate is a periodic tenancy. And then we have an estate at will, an estate at sufferance. The estate at years, which we started discussing, is the one that has a definite termination date with no advance notice. Don't have to wait for the landlord to call. I don't have to call the landlord. Death of the lessor nor the lessee will terminate an estate for years. Let's suppose that I went down to the beach and rented a place for the summer. As long as I'm dreaming, we'll dream big. I'm going to rent a big place right on the ocean, right here the waves come in, you know, and I'm going to rent it from June 1st to August 31st. Now that's an estate for years. I'm going to take possession on June 1st and August 31st. It's over. I'm going. There's no provision for me to keep staying there. 2 weeks into this lease, the landlord passes away. How does that affect my lease? No, it doesn't affect my lease. Let's say 2 weeks into it, I pass away. Does that affect the lease? No, the lease is still valid. And I know my children. As soon as that funeral's over, the three of them are going to pack up. They're going to be headed to the beach. They're going to be down there enjoying this place. Mama would want us to enjoy this in her absence. They would be there. So no, death of either party terminates an estate for years. The sale of the property doesn't terminate it. The new owner has to honor the lease. It's sold subject to the lease. So think about a vacation rental. I think this is a good way to help you remember how an estate for years works. It doesn't have anything to do with the length of time. It has to do with the fact that there is a definite date that this is going to end. What do you think? Thinking back to that situation where I'm down at the ocean. What if I went ahead and paid for the entire summer right up front? Would that change the situation any? No. What if I paid on a monthly basis? I paid June 1st, July 1st, and August 1st. Would that change it in any way? No. So it doesn't have anything to do with how the payments come in. So don't let that confuse you that you're getting the rent each month. It has nothing to do with how the rent payments are made. The key is it ends on a definite date. It has a definite expiration date. The next type of lease is a periodic estate, or next type of estate is a periodic estate. I think of an apartment situation when I think of periodic estate. This one is going to automatically renew for set periods of time upon payment of rent. So an estate for years, no renewal, periodic estate or tenancy, it renews. This is your most typical type of residential lease. I may go rent an apartment for a year, but there's nothing that says at the end of the year I absolutely have to be out. We can renegotiate another lease, or if the landlord doesn't want me to continue staying there, then the lease usually says something like you have to give you 30 days notice prior to expiration. Or if I don't want to continue, I give them notice. Or it could just go month to month. We could renegotiate, or we could just go and every time I pay, I stay. I pay, I stay. So it's periodically renewing. Every time the tenant pays, they get to stay for that period of time. There's got to be some advance notice given by the party, and that's the key here, the advance notice given by either party. Think a month-to-month rental, and maybe a period-to-period, month-to-month, week-to-week. Maybe that'll help you remember that one. I've said that the notice required is going to be the amount in the lease, or it's going to be run according to state law, correct? So North Carolina state law says that the minimum notice is, in a week-to-week lease, is 2 days. The minimum notice in a month-to-month lease is 7 days. The minimum notice in a year-to-year lease is 1 month. So you look at the lease first, because what's written in the legal document rules, but if there's nothing in the lease, then the default is the state law, and this is the law in North Carolina. The next estate that we're going to talk about is an estate at will. An estate at will is one that has an infinite duration because you don't know when it's going to end. And this one, the tenant is staying in the property at the will of the landlord, as long as they're happy with each other. So I guess as long as the landlord still loves the tenant, he can allow him to stay. But this one can be terminated at the will of either party. This one, when either party decides that they no longer want to be there, it can be terminated. So when the love runs out, either party can terminate the lease. It's also terminated by death of either party. Example of this one might be, I've had some friends whose parents had passed away, and they had the property was going through probate and had been vandalized a couple of times, and they were complaining. And another friend of ours in our little social circle was going through a divorce. And he said, well, I need a place to live. Could I rent the property? And they said, well, sure, we'd rather have somebody in there than it be vandalized. But we don't know how long you can stay, because we don't know when it's going to get through probate. When it gets through probate, we're going to put it up for sale because we want to, be through with this and divide the profits or whatever. So they rented it to Jim, and they said, we'll let you know. Now, during that period of time, Jim could also have changed his mind. He could have made up with his wife, right? They could have gotten back together. Or more likely, knowing Jim, he found another girlfriend. And decides he wants to go live with a girlfriend. But either way, it could be terminated by either party. The last type of estate we're going to talk about is the estate it suffers. In this one, the love is gone. This is a situation where a tenant is in a property illegally. The landlord is mad. He wants them out. They started out their agreement legally, but maybe they didn't pay rent. And they should be leaving, but they're still there. They've done something to violate the deed condition. It could be, and most typically is, not payment of rent. It could be that they're supposed to have 2 people living there, they've got 24. Or they have no pets, they've got 16. They violated the lease. And the landlord then is trying to get them evicted. During this period of time where it's a state of sufferance, the landlord can evict them, or if they come up with the rent at his discretion, he may accept the rent. And if he accepts the rent, then it reinstates the lease, and it is no longer in a state of sufferance. It goes to a periodic state, meaning that as long as they stay, as long as they pay, they can stay. So these then are the 4 types of leasehold estates. Any questions about any of the leasehold estates? Yes, Larry?
If you have a periodic one, you have a year-to-year lease, but then after the year, it goes month to month. You got to give 7 days or 1 month notice?
His question is, if you have a year's lease, at the end of the year, it goes month to month, do you have to give 30 days notice or 7 days notice? You have to look at the lease. If the lease says 30 days or whatever the lease says, that's the notice. The lease rules, the legal document that the both parties sign rules. If there's nothing in the lease, then it would default to North Carolina state law, which is 7 days. Yeah, thank you. A good question. Any other questions? Okay, if there's no other questions, I'd like for you to go back to your handout. You have a few more questions there on leasehold estates. Get back with your partner, discuss them, and then we'll come back together as a group. All right.